Welcome to today's Explainer lecture. Right, pay close attention, everyone. The topic today is Q16, Constitutional Safeguards for Independence of Judiciary. Now, note this down carefully. This isn't just another passing topic. We're looking at a highly crucial, recurring 16-mark KSLU exam question. If you're serious about securing top marks in constitutional law, mastering the structure and the exact phrasing of this specific answer is absolutely non-negotiable. Let's begin our analysis. Our agenda today covers 1. Introduction and meaning, 2. Constitutional safeguards, 3. Landmark case laws, 4. Importance, and 5. Conclusion.
Section 1. Introduction and meaning.
Now, I strongly instruct you to replicate the exact roadmap we just outlined right on page 1 of your answer script to impress the examiner and secure maximum weightage. Always start your answer script by explicitly stating that an independent judiciary is a basic feature of the Constitution. Using the term basic feature anchors your answer in the Kesavananda doctrine, and it establishes a strong, undeniable academic foundation for the rest of your essay. Now, let's read the exact definition you must write. Judicial independence. Judges are free from external influence and can decide cases impartially, without fear or favor. You've got to memorize this phrasing perfectly. KSLU evaluators heavily expect to see these specific words on your paper, particularly the phrase without fear or favor. It's the core essence of the judiciary's role. If a judge is operating under fear of the executive or seeking a favor from the legislature, the entire rule of law collapses. Write this verbatim.
Section 2. Constitutional safeguards.
For this section, I command you to write constitutional safeguards as a major, centered, underlined heading in your answer script. Let's examine the first set of safeguards. Appointment and tenure under Articles 124 and 217. Appointed by President via Collegium, judges hold office until retirement. Removal only by parliamentary impeachment. Grounds: prove misbehaviour or incapacity. When you write this on paper, format these as clear subheadings. Notice the sheer strictness of the removal process here. You must emphasize to the examiner the rigid, extremely limited grounds for parliamentary impeachment. A judge cannot be removed just because the ruling government happens to dislike their judgments. No, they can only be impeached on 2 absolute, constitutionally prescribed grounds: prove misbehaviour or incapacity. This guarantees extraordinary security of tenure.
Next up, financial protections. Fixed salaries and allowances cannot be altered to disadvantage, charged on Consolidated Fund, not subject to vote in legislature. Read these points and bracket them together in your mind. In your exam, you need to explicitly explain why this matters. Making salaries charged on the Consolidated Fund means they are non-votable. This is absolutely crucial because it brilliantly protects the judiciary from political blackmail. The Parliament literally cannot threaten to cut the Supreme Court's budget or reduce the judges' salaries simply because the court struck down a government policy. Their financial security is absolute after appointment.
Article 50. Separation of judiciary from executive. Read this directive principle strictly. When you reach this point in your exam paper, I want you to draw a prominent box around Article 50. Highlighting this specific article is vital because it explicitly mandates the state to separate the judiciary from the executive in the public services. Make sure you detail in your answer how this ensures the independence of not just the higher courts, but crucially, the subordinate judiciary at the district level. It effectively insulates local magistrates from the clutches of local executive authorities.
Moving on to powers and administrative autonomy. Power of judicial review. Control over own staff and procedures, transfer of judges under Article 222, contempt of court power. Let's break this down. First, the power of judicial review maintains the absolute supremacy of the Constitution. Courts can declare unconstitutional laws void. Crucially, pay attention to Article 222. Citing Article 222 shows the examiner that you actually understand the nuances of the Constitution. It states that the transfer of high court judges must be done in consultation with the Chief Justice of India. This is a vital safeguard that actively prevents the executive from punitively transferring independent-minded judges to remote areas under executive pressure. Furthermore, the contempt of court power allows the judiciary to punish anyone who disrespects its authority, thoroughly protecting its dignity.
Post-retirement restrictions. Judges are restricted from legal practice. I want you to write this as the final absolute safeguard in this section of your essay. Specifying this shows a complete top-to-bottom understanding of judicial insulation. Supreme Court judges are permanently barred from pleading or acting in any court within the territory of India after retirement. Why? Well, you must explain to the evaluator that this prevents severe conflicts of interest. If a judge knows they'll be returning to practice, they might be tempted to favor certain powerful litigants, or even the government, just to secure post-retirement benefits. This restriction totally neutralizes that threat. Section 3. Landmark Case Laws. Now listen very closely. Merely listing the constitutional articles will only fetch you average marks. It's the deep analysis of these landmark cases that elevates a standard 10-mark answer into an outstanding top-tier 16-mark answer. We have S.P. Gupta v. Union of India, also known as the First Judges Case, versus Supreme Court Advocates on Record Association v. Union of India. Direct your pen to underline both of these exact case names prominently on your answer script. Let's do a deep breakdown of S.P. Gupta. The primary issue, the brief facts here, revolved around the role of the executive versus the judiciary in the appointment of judges. The crucial ratio decidendi, the final verdict of the court in this First Judges Case, disastrously held that the word consultation in Article 124 did not mean concurrence. It effectively gave primacy to the executive branch in judicial appointments. So, what's the relevance? This case was heavily criticized because it severely weakened judicial independence, allowing the government way too much control over who gets to sit on the bench. Write this case law in a separate boxed format to immediately capture the KSLU evaluator's attention.
This brings us to the most critical turning point, the shift to judicial primacy. Second Judges Case overruled S.P. Gupta, established Collegium system, gave primacy to judiciary in appointments. Let's expand comprehensively on this. The Supreme Court Advocates on Record Association case, widely known as the Second Judges Case, is the absolute bedrock of modern judicial independence in India. The background facts here stem from the widespread criticism of executive overreach that followed the S.P. Gupta ruling. The Supreme Court's ratio decidendi here spectacularly overruled its previous stance. It ruled that consultation with the Chief Justice actually means concurrence. It literally stripped the executive of its V-power and established the Collegium system, ensuring that the judiciary itself has the final say in appointing its own members. The absolute relevance of this case cannot be overstated. It completely restored true judicial independence. Articulating this historical shift clearly on paper is exactly what secures those top university marks.
Section 4. Importance. After your intense case law analysis, you need to snap the evaluator's attention back to the broader picture. This is the next mandatory heading required on your exam script to prove you understand not just the how, but the why of the law. Importance of independence. Protects fundamental rights, maintains checks and balances, ensures fair and impartial justice, strengthens democracy. Read these verbatim and memorize them. Why format it this way? Because organizing these specific outcomes into crisp, distinct bullet points demonstrates a holistic, structured understanding of constitutional law to the examiner. It proves that you see the judiciary not merely as a dispute resolution body, but as the ultimate guardian of the entire democratic framework.
Section 5. Conclusion.
A strict reminder to all law students. A perfect KSLU law paper must never, ever end abruptly. Don't just stop writing when you run out of facts. You must always feature a definitive concluding heading to wrap up your legal argumentation professionally. Independence ensures the judiciary remains free, impartial, and effective, upholding the rule of law. Judicial independence is essential for the success of democracy itself. As we conclude this explainer lecture, I want to leave you with a provocative thought to really anchor your understanding. If the constitutional safeguards fail and the judiciary falls to executive pressure, who remains to protect the Constitution from the state itself? Keep that question in mind as you study. Master the structure, cite the cases perfectly, and you will ace this question. Thank you for attending.